All right, welcome back to another special report from the unknown. My name is Michael Volpe. I report from Chicago, Illinois. That's in Cook County, Illinois. And I write at michaelvolpe.substack.com. And my broadcast partner, as always, Richard Luthmann, somewhere around Fort Myers, Florida, in Lee County, named after Robert E. Lee, the Confederate general. And you write at luthmann.substack.com, spelled Luthmann. Substack.com. And we are going to talk today about an update in the Jeremy Hales case. Hales sues a bunch of people frivolously and then uses that for YouTube content. He's got a popular YouTube channel, but he sued a guy named Dan Owen. He's not the elected prosecutor. There is a guy above him who's the elected prosecutor, but he is the prosecutor over Levy County, which is where Hales sometimes lives. And I think that in this case, Hale's hubris may bring him down. But what I wanted to do was I wanted to start. We talked a little bit about this case when Hales filed his initial complaint. And the first like 2 minutes, I think, explains what's going on. And then we're going to talk about the update. The guy's name is Daniel Owen. Now, I thought he was the elected. I don't know if he was elected, but he's the Levy County, Florida prosecutor. But there's actually a guy above him. I think that guy is the guy who's elected. But be that as it may, Foreman, Hales had a protective order in Ohio against Michelle Preston and John Cook, and he claims he wanted it executed, and they refused to execute it, meaning Owen and his office. And as a result, they are arguing that they're civil, or what is it, constitutional rights, because they're saying that under this law, the full faith and credit, that it should transfer over. And they're all right. So that briefly describes the what was going on. Hales had this protective order that he got in Ohio. He lives in Ohio. John Cook and Michelle Preston, they are his kind of neighbors, definitely live near him. He sues them for a bunch of different things. He also got this protective order in Ohio. He claimed that they kept violating it. Now, since they live in Florida, he has to go to people in Florida to have it, quote unquote, executed. Interestingly enough, he didn't really specify what execute means. But he then sued because he claimed that the prosecutors refused to, quote, execute it. So in my initial article, or enforce it, not execute, enforce, but same difference. So I said, I said several different things. The first thing is, Hales claimed that when he brought this to Owen's office, and he actually didn't bring it to Owen's office, he brought it to the Levy County Sheriff's Office, and they, I think, consulted with Owen, who asked them to email it to him. He thought that it was an improper, possibly fraudulent order for protection. Now, as I pointed out, he then later said, "No, it is proper." So they didn't put that into the lawsuit. But and we'll go over it. In his response, the attorney general is the one that's helping him. He took it like a step further. And so here he says that it's fine. So the premise that they said, where he was investigating them and he was doing this, that, and the other, that seemed to be bogus, because after the investigation, he said, no, it is proper. The second problem they had was the violations of the protective order were investigated by Levy County Sheriff, and every time I thought they were found to be meritless. But when we look at his response, it's even worse than that in the context of suing Owen. But the third problem, and the main problem, even if those first two things don't exist, prosecutors have near total immunity And the idea that you can sue a prosecutor because he doesn't prosecute a case in a way you don't like seems to run counter to the basic principle that every lawyer should know as far as suing a prosecutor. And Jeremy Hale's lawyer is Randall Shockett. So, anything you wanted to add on that?
Well, I'll start with immunity first. You hit the nail on the head, Mike. I think that the response even said, look, it sounds like you're going after what the sheriffs did, or what the deputies did, or what the cops did. But you're coming after me, the prosecutor. Prosecutors have absolute immunity in all circumstances, okay? There's an issue about qualified immunity. Police usually have what's called qualified immunity, which is a lesser immunity. But it's like, this is like day one law school type stuff. The fact that this was even put into the court is a problem. And number two, the other issue is, and you touched upon it, it's something that we have in federalism and dual sovereigns and respect for sovereigns in the country and the comity of states. We respect other state governments. Just because you have full faith and credit, it's not automatically, self-justiciable, meaning that you have an obligation to look at, if you're the executive branch of the receiving state. So this Ohio made the order, and the receiving state is Florida. So the executive branch has an obligation to look at the order, but it has no obligation to enforce an order that is against the public policy of the receiving state. Meaning that the policy of the state has laws that the legislature has put into place, the Florida legislature, as well as executive orders that the governor has put in place, as well as standing orders by the attorney general. If it violates any of those things or comes into contact with any of those things, there's no obligation for them to enforce an out-of-state order, automatically. So there's a whole review process that has to take place, and they said that very clearly in the responsive papers. That look, I don't have to do. It's not automatic. I don't have to do anything. If I look at an order and I want to review it and I want to do my investigation and make my determination as an executive officer, I have a right to do so. And it's dead on that grounds too. He has no obligation to go and enforce that order. Unless and until he says that, well, I have to enforce it. I'm bound. I'm legally bound to.
Right, and I don't know if you're ever legally bound. You prosecutorial discretion always applies, and if you don't think you can get a conviction, that's one reason why you wouldn't enforce it. And as we went over it, Hales is coming up with these bogus reasons to violate them, and he doesn't like that the sheriff's office is disagreeing with him, and so he goes and sues the Levy County prosecutor. But I wanted to read these two paragraphs, which don't even have a direct relationship to the motion to dismiss, but I think these two paragraphs are important for the larger context. So Mr. Hales and Ms. Risk, who is his girlfriend, each reported violations of their protection order to the Levy County Sheriff's Office and the 8th Judicial District Circuit State Attorney filed charges in Levy County. So they did. There's all the charges. Plaintiffs then sued Preston and Cook in the Northern District of Florida. They give the case number. And Preston sued plaintiff in Levy County. They give the case number. Preston filed for Chapter 7 bankruptcy. They give the case number, resulting in automatic stay. A few months later, Preston filed this lawsuit against the 8th Judicial District of the Florida State Attorney, Daniel Owen, for alleged failure to enforce the protection order. If you're cheering this guy on, what are you cheering on? This is just a flurry of lawsuits every which way. This is what this guy does. It's what he brings. It's just nonstop legal action. Why do you think that's attractive? Why do you think that's good? Why is that something you want to cheer on? He's putting people into bankruptcy. He's suing them. They're suing him in multiple jurisdictions, lots of different lawsuits, prosecutions, you name it. Why would anyone think his fans are really, in my opinion, the primary villains, because they are cheering on this really reprehensible behavior? Am I wrong?
I agree. I think you said it recently in an article. If the fans are the primary villains, then the judges are the primary enablers. We have a situation with, I think we have a weak, is a good word to say, a weak magistrate judge who hasn't basically taken the reins. We've covered a lot of federal court cases. We saw one in Missouri with Judge Devine and a case there, and that judge basically called in the plaintiff, who happened to be an attorney, and said, you know, you have 7 days to correct this filing or amend the filing or show cause, and he kept them on a short leash. The problem here, I think, is that the magistrate is not keeping anybody on a short leash, especially Jeremy Hales, who's a vexatious litigator. Every chance he gets, he sues, and he has no problem not to sue. You've discussed the term a lot, coined by Bruce Matskin, PALMA, protraction of litigation and multiplication of proceedings. Bruce believes, and I think rightly so, that a lawsuit is probably the best drama that there is. You know, you have all these words and everything else, and it's ready-made for the media. It's ready-made for the written media, for the spoken media, for videos, for all different types of media production. And that's what his whole little echo chamber has. You know, he calls it an ecosystem echo chamber, whatever is him, where he has 750,000 viewers, and then he has all these people drifting off of him. He has Tug, he has Megan Fox, you know, he has
Shizzy.
He has Shizzy. Has Rosalind Duke, you know, you name. He has a whole group of people that it all trickles down, and they make content.
And they only make this content because then he mentions them, and they get some of his viewers. They are extremely reprehensible. But the idea that you find any of this stuff entertaining, Michelle and John are trying to take care of a 6-year-old with a serious malady that you all think is fake. And in the meantime, they got a flurry of lawsuits from some loser whose own family won't talk to him. So the number one reason to dismiss, Mr. Owen is entitled to absolute prosecutorial immunity. That was my number 3 because I was setting it up. So he made and this is the gentleman, I think it's from the Attorney General's office, makes the argument that you are suing someone for a decision they make as a prosecutor. And you can't sue them. And as you can see, he cites case law. Having absolute immunity in civil damages actions would be of little consequence if it could only be asserted when a defendant prosecutor correctly complied with all his legal obligations, in which case there would be no claim. As a preliminary matter, the full faith and credit clause does not mandate unquestioning obedience, and that's what you said. Just because one jurisdiction has to honor the protective order doesn't mean that you have to file charges for violating a protective order. It is true that if you violate a protective order that's in Ohio and you violate it in Florida, it does have full faith and credit, but that doesn't mean they are required to file charges. That's the argument they make. These are all, it seems, basic arguments that even a layman should understand, and yet a lawyer was filing this.
It's a disgrace, and you see these on the dockets that Hales is involved in. These are dockets are dozens, if not hundreds, entries deep, and all it does is these are words that are being created to bolster content. As a lawyer, Randy Shockett, the attorney, and Doreen Turner Icolas, his affiliated attorney, are drafting these papers and filing these papers knowing full well that the filing is in bad faith. I think that, you know, this might be the Rubicon moment, like you said, Michael, because they've just pissed off Florida law enforcement. You have the attorney general, you have a county attorney, you have the county sheriff, you got them all with their ears up now. And, you know, where Jeremy Hales before was, okay, fine, let everything go. And they kind of said that at the beginning, where they said one side complained about the other criminally and the other side complained back, and it got all dropped, and we kind of let everything go, and then they sued each other in civil courts. Well, I don't think they're going to be so laissez-faire with Jeremy Hales going forward. If this guy's going to be a pain in the ass to the county, to the state law enforcement, then they're going to do what they got to do. You know, they're not going to give him any leeway. They're not going to be laissez-faire, hands off with him. So that's why I think, in my opinion, he's still sitting up in Ohio right now in the cold weather, when normally in years past he'd be down in Florida already. I think he's afraid of what might happen to him in Levy County because of his transgressions.
Right. Well, he can be taken from Levy County, or to Levy County anyway. Now there is one other thing in this argument. I think what the Attorney General's office said is there is a carve out in terms of immunity if you offer advice. Do you not have immunity from advice that you offer?
Well, the point is that prosecutors do not have immunity outside of the litigation process. So when
Hmm.
it's an investigation process, when you're talking about investigations and
Hmm.
how to conduct investigations and that, then you've gone into not being a prosecutor. You're the same level of qualified immunity as a police officer. That's also about the advice. So the advice issue is more about when an officer of the law comes to the district attorney or the state attorney and says, we
Hmm.
want to do this X, Y, and Z in our investigation. Is this legal to do? That
Hmm.
potentially falls under a qualified immunity scrutiny because
Hmm.
if they give bad advice and the police act on it, then it's something that's actionable potentially. But
Hmm.
that being said, it's in a very specific area. It's about and usually it's pre-arrest, pre-indictment, pre-type
But
investigations, and
if
they
your
attenuated.
advice is I I'm not charging these guys, so don't even bother to investigate.
That's
Is
not
that
advice, Mike. That's
right?
not advice. The advice we're talking about is I have a recording device. Can I plant it here? I have a recording device. Can I have an
Oh,
informant plant it
all
there?
right.
I have this type of evidence. I have an infrared ray gun? Can I shoot it
Hmm.
into the house to see if they're growing pot? It's stuff like
Hmm.
that. Those are the questions that you ask when there's a long-term investigation. Think about them tracking down a drug dealing ring,
Hmm.
organized crime of that sort. When you have these investigations that they build for months and for years, of course you have questions about what the limits of a search could be. That's the area where this happens. It's not about execution of what's called, quote unquote, full faith and credit orders. That's no way, shape, or form something
Right.
that could be
And they
construed as legal
in
advice.
in in the motion to dismiss the case, they cited the example where the prosecutor gave advice was hypnosis is fine. So he was advising in a certain tactic as opposed to the law. And
It's a
so,
collection of
so
evidence, Michael.
right.
Collection of evidence.
So nothing that Owen did fell outside of his immunity. Am I getting that right?
100%. I don't see it. And
Right.
even if it did, it's not stated in that complaint, right? It's not
Hmm.
stated what's so egregious that Owen
Hmm.
did to even be looked at. This is
Hmm.
a complaint that's frivolous on its face. I
Right.
think that I really wish that the judge in this case would borrow from Judge Devine in Missouri and give
Hmm.
Shock it 7 days to amend or show
Hmm.
cause why he shouldn't be sanctioned. Because
Hmm.
this is a
Right.
sanctionable document right here. This is about
Right.
as bad as it can be.
And the motion to dismiss asked that it be dismissed immediately without even giving Shockett a chance to amend it or to respond. And further, under this law, only those protections orders issued by a court that, quote, has jurisdiction over the parties and manner of the law state, and, quote, they go on. Um, Mr. Owen's questioning, therefore, of the strained party tied in his questioning of whether the plaintiff lied in their petition was entirely proper under state and federal law. What they're arguing here is Owen wanted to make sure they weren't violating a separate federal law by even bringing this protective order forward. And as we noted, after investigating it, found that he didn't. So, oh my God forbid anybody looks at you funny, you're going to sue him. That's basically the tack that Jeremy Hales takes.
Yeah, it's become transparent at this point. And the fact is, and we said it before, it's
Mm-hmm.
it's not so much Jeremy Hales or his audience; it's the lawyers that are enabling this that become the
Mm-hmm.
biggest
And the
problem.
judges.
That's the point.
And so and lastly, let me read this. Plaintiff's lawsuit fails because none of the alleged harm can reasonably or logically be connected to Mr. Owen's conduct. This 1983 claim, that's a civil right claim, requires proof of an affirmative causal connection between the defendant's acts or omissions and the alleged constitutional deprivation, the overarching rule is that where a deliberative autonomous decision maker stands between a defendant's actions and the plaintiff's injury, the defendant's action cannot be the cause of the plaintiff's injury. And the plaintiff's count one claims as a direct proximity, now he's quoting Hales, as a direct and proximate result of the defendant's failure to enforce the protection orders, plaintiffs suffered continuous harm to each plaintiff's victim's sense of safety and well-being as a direct result of defendant's failure to enforce the protection orders, including without limitation, quote, physical harm and threats of such harm, emotional and psychological harm, and they go on. A civil, and then they say that they go on to allege, quote, Preston and Cook enlisted others in a civil conspiracy to harm Hales as a result of Preston and Cook being emboldened by the defendant's failure to enforce the protection order. I mean, unbelievable. Plaintiff did not allege that he had any connection to the non-parties, that the non-parties were aware of Mr. Owen's investigation of the protection order or any other circumstance. First of all, these are all conclusions and allegations that he's making, but he's basically saying, if you had only enforced this protection order, then I would have been saved from these unnamed acts from Preston and Cook.
Yeah. So that's the legal doctrine of what's called causation. And the doctrine exists in many places in the law, but there are two parts of causation, where there's a legal cause, there's an actual cause and a legal cause, or what's called proximate cause. So just because something causes something else, because this person failed to quote unquote investigate, and then I had all these unspecified damages. Well, you can say that that's an actual cause. That's fine. But it's not what's called a legal cause or a proximate cause, meaning a cause that the law recognizes for compensation, right? There needs to be an actual proximate cause for, and that's that there has to be some type of connection between the activity and the harm. And so what Shaka fails to do here in this terribly drafted pleading is say what the specific acts that the Levy prosecutor failed to do, and how that's tied to the actual specific harm that were felt by Jeremy Hales.
Hold on. He failed to enforce the protective order, and as a result, they were emboldened. What's wrong with that argument?
That's not a liberty interest. So you have to connect the causation. He caused them to be emboldened. That's not something that the law can compensate. You know, it's out of control. It's attenuated. There's no direct connection there. You know,
so yeah, you're getting inside people's head. Last thing I want to talk about, and then we're going to look at the original complaints. We'll do it backwards, having looked at the response. Then they argue qualified immunity. Why would you argue absolute immunity in number one and then turn around and say, also he has qualified immunity? If he has absolute immunity, obviously he has qualified immunity. Why is he making this third argument?
Even if he has absolute immunity, right? Even if the judge found, okay, fine, you don't have absolute immunity, let's say in some crazy way, the qualified immunity is a bar to recovery. So he's saying, look, I have a legal defense and absolute immunity, but I also have qualified immunity. I have two different types of immunity. You knock down one, I'm going to have the other.
Right. And the key part is what we've talked about a few times, and what we talked about when this was originally filed. Government officials performing discretionary functions generally are shielded from liability for civil damages insofar as their conduct does not violate clearly established statutory or constitutional rights of which a reasonable person would have known. And there is there's a very controversial case, a very sad case out of where I live in Chicago, where a guy with like 50 criminal, I don't know if they were convictions, but I think he was arrested 50 times, and a judge let him out of jail, and then he got onto a train and got into an argument with a 26-year-old woman, and he set her on fire. And as reprehensible as it is that those judges let him out of jail, they are immune from a lawsuit. Am I right?
Yes, because there's no what's
Because
called foreseeability. It's right there. It's that
right,
a
right,
clearly established statutory or constitutional right of which a reasonable person would have known. No
right,
reasonable person in that circumstance could foresee that result. They're
right.
acting within the bounds of what they do. It's conduct. It's traditional
Right.
conduct. It's statutory. The statutory
And
constitutional
and the
rights are
same
protected.
the same thing here. Just because the prosecutor didn't want to prosecute your violation of a protective order doesn't mean you get to sue. Am I right?
Yeah, and just because the prosecutor investigated it and didn't come to the same conclusion,
Mhm.
that he has every right to do that.
Right. They basically they don't like the conclusions that this guy has come up with, and as a result, they're going to sue. So this, I believe, is the original lawsuit. So let's go through it. So they say plaintiffs are protected persons under two valid orders of protections. The protection orders were issued in Ohio. They say that uh, defendants were defendant was required to give full faith and credit to the protection order and enforce them as if they had been issued in
No,
Florida.
that's a legally wrong paragraph. You know why? That second clause, right? Full faith and
Mm-hmm,
credit does not equal enforce them as they've been issued in Florida, because
mm-hmm,
what would that mean? If you take that, if that statement is taken on face value,
mm-hmm,
it means that Florida must delegate its responsibility and sovereignty to the state of Ohio under the
mm-hmm,
full faith and credit clause. That's not what the full faith and credit clause says. One state does not delegate its responsibilities to the other. The executive branch of Florida does not delegate its responsibilities to the judicial branch of Ohio. That's not
mm-hmm,
how it works. This shows a
mm-hmm.
lack of understanding of the law, of the Constitution, of
Right.
federalism, of states' rights. It's like
In
third grade
in
stuff. It's a
legal
problem.
in legal jargon, what it means is the state of Florida may enforce the protection order from Ohio, not shall enforce, right? It is enforceable in the state of Florida. It is as legally valid in the state of Florida as it is in Ohio. That doesn't mean you are required because someone comes to you with a violation of a protective order to immediately uh, to immediately
And,
arrest them. And
and
I,
Mike,
and I think we glossed over this. Owen's office did, in fact, issue charges that they later dropped against Michelle Preston and John Cook. So, in fact, they did enforce the order. It's even worse than that.
and the other thing is, if you
Mm-hmm,
want to take an order from Ohio,
mm-hmm,
from the judicial branch, and you
mm-hmm,
want it to have the full power of Florida law, there's a very simple way to do that.
mm-hmm,
Bring it to the judicial branch in Florida. Start a
mm-hmm,
proceeding in Levy County. Bring the
mm-hmm.
order to the judge as
He
show
tried
as
that.
the evidence and
He
enter
tried
that
that, and
order.
that got denied. So
I
they
know,
try
and
a,
so that's the
here they try some legal I don't know, legal gymnastics, and instead of enforcing the protection order as required by federal law, defendant refused to recognize the validity of the order. Defendant initiated an investigation into whether plaintiff Hales has been truthful when obtaining the order in Ohio. Defendant, in an email dated 10/30/2023, and he says, and then we've seen this email. So they are in this complaint arguing that because he initiated an investigation to them, he refused to enforce the Ohio order. And and they went through it, the AG's office, which represents Mr. Owen, that one, he was making sure that they weren't violating Florida law. Two, he has prosecutorial discretion. And three, he did bring charges. So on all three
and and
counts,
and
your argument is frivolous.
the other point, Mike, is this:
Mm-hmm,
Florida has an interest in protecting its citizens.
mm-hmm,
Preston and Cook are citizens of the state of Florida. Jeremy
mm-hmm.
Hales is not. So
Right.
if the citizens of Florida state, no, this is balderdash. This is something that never should have been here. This is all false. He's somebody from another state saying X, Y, and Z. The state has an interest in protecting its citizens at the highest levels, and so
Mm-hmm.
they have always have that right to do that.
All right. Now, I did want to talk to you about this. Remember, you if if the prosecutor issues advice, they aren't necessarily they don't necessarily have immunity. Am I right?
It depends. Yeah, they're usually in the investigative
All right. So
area.
now here is. All right, I can't. All right. I reviewed the assistant state's attorney's email regarding this matter. It reads that defendant would caution against enforcing this injunction. Ms. Rizk was made aware of this and was told this report would be for documentation only. Ms. Rizk advised she has a video of the event, which I will attach to this report when it is provided. Does he lose his immunity by advising defendant would caution against enforcing this injunction?
There's a difference between advising,
Mhm.
right? Advising some member of the public as to what the activities of law enforcement will be versus advising law enforcement officers on the actions they should take. They're taking the advice. It's a class of people that doesn't even apply to the statute or to the immunity doctrine at all. Think about it. One of the things that law enforcement does is they advise the public of what's going on. What's the status of our investigation? Well, we're advising the public that the person is still at large. Can that prosecutor then be brought up for qualified immunity violations because they advised the public that somebody was at large? No, that's how crazy this concocted story is, because the advice doctrine only goes from the prosecutor to law enforcement. It stays when it stays within law enforcement, not to members of the public. But because they had mail order Martha, Jeremy Hales' girlfriend, because they had her talking to law enforcement, doesn't change anything. They're just talking to law enforcement. It's not advice.
Okay, and this last thing is the thing we went over, where they're making a leap between Mr. Owen's failure to enforce the protective order and this campaign that they allege Preston and Cook went on. And then they go through the relief that we also went through. So are we missing something? This
I think
is like a very frivolous lawsuit against a bulletproof defendant that you can get into a lot of trouble for filing if you were a lawyer. Are we all missing something? Is Randall Shockley about to bring in some legal razzle dazzle and impress everyone and show them just how great a lawyer he is?
We said it right on day one. This is a nothing burger case, and Randall Shockley is the legal equivalent for the Simpsons fans out there, a Lionel Hutz, right? He's the bottom barrel lawyer that they find, and this is all that he can do basically is just churn out paper. And him and Doreen Turner Nicholas have a little factory there that is devoid of ethics. It's ethically challenged, in my opinion, and they pump this stuff out without regard for what the law says, without regard for the facts. Without regard for the bad faith motivations that their client has. This is stuff that's textbook sanctionable under Rule 11 of the Federal Rules of Civil Procedure. And I think this might be the case where they get taken to task. I really do.
All right. And I want to read this paragraph because this is, and again, this comes from a lawyer in the AG's office. Plaintiff's complaint lacks arguable merit in law and fact. Although Rule 15A typically permits amendment once as a matter of course, it does not require the court to allow amendment where the suit is frivolous. Even were plaintiffs proceeding pro se and the court required to construe plaintiff's claim liberally, the court would still be warranted in dismissing with prejudice if amendment would be futile, because amendment is, quote, unnecessary if the claims are patently frivolous. Plaintiffs here, though, are represented by counsel. The court should hold plaintiffs to the strict pleading standards under the federal rules and under Iqbal, which is a case they've cited, and Twombly. No claims based on the facts alleged would survive a motion to dismiss. The court should dismiss with prejudice. Do you agree with that paragraph?
So yes, what they're asking for is a dismissal with prejudice. Don't give them another bite at the apple to amend. The cases that they cited, Ashcross v. Iqbal and Twombly v. Bell Atlantic, are two touchstone cases by the United States Supreme Court that interpret Rule 8 and Rule 9 of the Federal Rules of Civil Procedure that talks about the minimum pleading standards when you file in federal court. And what he says is, what Owen says is, look, even if this were a pro se party, a non-represented by counsel, where the court is obligated to give them a lot of leeway, give them read the arguments the strongest way that they suggested. This is not something that would even pass that muster with a pro se party. And here, it's even worse because it's represented by counsel. These are drafted by counsel. These are drafted by Shockett and Terry Nicholas. The case should just get tossed, and frankly, sanctions should ensue.
He didn't ask for sanctions, but this guy is the one who filed it. Anthony Dean Johnson, Senior Assistant Attorney General. Why is the Attorney General's office representing Mr. Owen?
The Attorney General's office represents the entire executive branch. And
right.
Mr. Owen is the executive branch.
Something that Randall Shockett should have known. So if he is surprised that someone in the Attorney General's office is representing Mr. Owen, then he shouldn't be. I think it's possible that the dominoes will fall. There is a separate frivolous lawsuit that he's filed against 11 people. You are one of those 11. It is equally frivolous. The judge is taking his time. However, there is a scarlet letter list that appears in September and March. If you have sat on motions for 6 months. In September, the motions weren't 6 months. March, they will be well over 6 months. Sometime between now and March, the judge, that is a magistrate, Zachary Belay, though I do expect him to rule on that because he doesn't want to be one of the people listed having motions sitting out there for like 6 months plus, because that makes him look really, really bad. So I think this will get dismissed soon and followed by the order may be reversed, and then the dominoes may fall against Mr. Hales, and I think that his hubris will take him down. Suing a prosecutor was not wise.
Let's play judge right now, Mike. Mm-hmm. So let's say you're Randy Shockett, right? Mm-hmm. So you come in with this Levy County case against Owen to the judge, and I asked you, okay, so Mr. Shockett, explain it to me like I'm an 8-year-old. Mm-hmm. Why should Mr. Owen be held liable for civil rights violations? Please explain this to me like I'm an 8-year-old. Can you come up with any answer to that question?
I can't. I would say he kept arguing that the order wasn't valid, and the order is valid, and as a result of him arguing that the order wasn't valid, he never looked at the merits of the order.
How is that a civil rights violation that takes him outside of his duties as a prosecutor?
He's required by the full faith and credit clause to honor that order. He refused to honor that order, and that violated my client's civil rights.
Did he intentionally refuse to honor the order? Did he do this because of?
Yes, because he didn't want to look at the merits of the order. He only wanted to question whether my client had done something wrong, and he didn't do anything wrong. And rather than looking at the merits of it, he questioned him.
Didn't he investigate the papers that were put in front of him? Doesn't he have a right to investigate?
He does not have a right to investigate. That order is legally binding. He knew that order was legally binding. My client is above the law, sir.
Oh, that's right. Okay, so I forgot this is a monarchy, and that Mr. Hales is king. I forgot about that. I'm sorry. I'm sorry about that.
Listen, I would, if I was the judge, I would hold a hearing and say, am I missing something? Because you are an attorney. You should know that you can't bring this case. What is it here that we aren't seeing? Why are you bringing this case? And if I don't hear something, there's got to be sanctions.
Like, honestly, you have to have something more than mere speculation. Like, if you had it on tape with some of the people in that office saying, "Oh, I don't like this guy because of he's from Ohio. I don't like this guy because of his skin color. I don't like this guy because of his religion. I'm not going to do this because he's a prick and I have a personal problem with him." You have to have it like in recording, right. And be able to say something like that to even get yourself in the ball game where you could say with a straight face that immunity should be pierced. You know, that we're talking about a civil rights violation. Civil rights violations are pretty tough to prove, and they only fall into very, very specific classes. Just because you feel like you're injured doesn't mean you can recover on a civil rights violation. You have to either be a protected class or protected type of activity that they breach. And so it doesn't sound to me like any of that happened at all.
Right. And look, we've talked about it before. This is what elections are for. There are priorities that you can't prosecute every case. That's impossible. So you prioritize one over the other. Some prosecutors are tough on crime. Some prosecutors are tough on some crimes. That's what elections are for. This guy represents the elected official. You prioritize one over the other. If you don't think there's a case there, that is prosecutorial discretion. This we'll see. I think Shockett will be given a chance to respond. Maybe he's going to be able to pull in some.
He gets a chance to respond, totally.
Right, but they're asking for it to just be dismissed. But we'll see. So far, it's played out exactly as I thought. And I don't even think that Hales has made that much YouTube content out of this. So I don't know what he was thinking. I think that this is hubris. And this and that other 11-person case, I think will be decided within a month or a month and a half of each other. And you could have two dominoes where a court calls the lawsuits frivolous. And then hopefully people will see that this guy is filing frivolous lawsuits for YouTube content. Anything else you wanted to add, and then we'll wrap it up.
Well, just the kicker is that he's just recently filed a motion for more time to serve me in the case. He hasn't served me in the case on a complaint that he put in June, right? To tell you, like you said about that clock and the bad boy list that the judges go on when the motion set. In June is when they amended, and it's only 90 days under Federal Rule 4. We're at the end of November.
And the judge gave him an extension. This is in the other case, and now he's asking for another extension, and that extension runs out.
Mike. Right. If he gets another extension, it's definitely going to go past that bad boy list date, because they're going to try to come and serve me, or they're going to say I'm served. There's going to be litigation on that, and there's going to be additional litigation on jurisdiction. So there'll be many, many motions filed. It's going to go well past March. So I'm hoping that the judges recognize.
He can rule on the motions that are outstanding. He should have dismissed that case. That case is as frivolous as this case. Maybe the way that Belido acted in that case gave him confidence that the same thing would apply here. But suing regular citizens is not the same as suing a prosecutor. And we will be back later.